After understanding what you are allegedly having done that led to this criminal charge against you, after you enter a plea of not guilty, then comes a phase of discovery where the state has to provide you by law all the evidence that they have against you. All the videos, all of the documentation, all of the witness statements, all of the snitches information, all of that stuff has to be provided to you so that you can evaluate your case. And nowadays, the government has made it easier for you to be able to get the discovery because now is in electronic form. So in most cases, if you've hired an attorney or if you can't afford an attorney, you can have an attorney appointed for you. The government provides your attorney this in electronic form. One of my pet peeves is that if somebody calls me up and says, Stephanie, I know you're not taking this case, but can you at least look at the discovery for me? And I'll say, sure, give me an overview of what's in it. Well, I haven't seen it yet. How long have you had the discovery? I've had it for about 2 months. So in 2 months, you have not reviewed your own discovery. In 2 months, you telling me that you're looking at going to prison and you have not looked at any of this information that's out here that they're using to go ahead and charge you. You have an obligation to look at the evidence against you. And what we typically did when I was doing this is we would set what we call discovery meetings, where we would take all the evidence and we would sit there with the client and show them the evidence. That's the meat of your case. That is where you either find the information to provide a strong defense to the case, or that's the way you find information that you could use to mitigate if you can't find a strong defense, or that's the phase of the case where you look at it and you say, oh man, we got some problems. Discovery. Make sure you look at it in detail.